So thank you very much, everyone. Today I'm going to have a brief look at succession planning, particularly within structural engineers and the legal process of selling your practice. We've got this name of M&A, but really it's the follow-on from what we're talking about with succession planning, and also what Emma was just picking up on, what happens if you are closing down your practice. So succession planning is key to the future of pretty much every business. But like in the Tudor succession, it can be problematic. People can lose their heads. It requires you to think about what you're doing. And for many of us, thinking about when we leave a business is something to put off. It's not something to deal with now. We've all got immediate concerns. Satisfying clients, hiring staff, adequately and really doing a good job on the current project we've got in front of us. But failure to deal with the issue now, the issue of succession, can potentially save up huge problems for the future. And really, in my view, succession planning should be a process that you start early on. The best planning is gradual and thoughtful, with lots of sharing of information, knowledge and perspective, so that it's almost a non-event when it actually happens. Think about your future exit from the practice. Where do you want the business to be? What are the goals you're looking to achieve? And structure your business in such a way that it actively encourages succession planning. I'm going to touch on share options in a bit, which might be applicable to some of you. But if all the equity, if all the shares are owned by maybe one or two people, this is maybe a structural problem that you've got for the future. And also ensure that you put in place adequate internal agreements. So that's an LLP agreement if you're an LLP, and a shareholders agreement if you're a company. Because there needs to be agreed mechanisms in place to govern the management of your practice, what happens if someone leaves or dies, and what happens if there's a dispute. And I've seen many small practices with no shareholders agreement where there's the equity, the shares are owned by two individuals, where one wants to leave, and if there is no shareholders agreement to deal with that mechanism, what happens? It can really turn into quite a nasty dispute. With different valuations, working out what happens. And often in that scenario, it really causes a problem for the business. When looking at your internal development of staff and external recruitment, there are a few key areas that I think you should be focusing on. And those are identifying those with potential to assume greater responsibility within your practice. You need to provide them with the developmental experiences so that they can move into those key roles as soon as possible, and engage all of the existing management, so everyone at management level, in supporting the development of those potential future leaders. Where you're missing key skills or where you want to bulk up on an area, obviously that's where you can be looking at external recruitment. And share option schemes can be an effective way of incentivising and retaining staff without having to give away much ownership early on in their careers. And an enterprise management incentive scheme is quite commonly used in smaller practices. It's a government-backed scheme, very tax advantageous, which allows you to not only reward your employees with options that have tax advantages, but also offset the cost of that scheme against the company's tax liability as well. And one form of succession planning is actually to encourage your own management to think about some form of, we've got it down here as a management buyout, but it's just, that management taking over and buying your interest in the practice or your shares going forward. Something we've seen, quite a great deal of interest in, particularly amongst construction professionals, and it seems to be the architects who are the first movers with this, is employee ownership trusts. And that's the kind of John Lewis model of employee ownership. It's a special form of employee benefit trust. And the incentive for owners is that the government has introduced some very, very generous tax advantages and breaks for it. And what it effectively does is it allows employees to indirectly buy the company from its shareholders without them having to use their own funds. What they're effectively doing is it's the vendor, it's the seller who's funding it over a period of time. This means for the person who owns the business, it creates an immediate buyer without going out to the market to find a buyer. Shareholders can sell their shares at full market value, and one of the big drivers for this is that there should be no capital gains, income or inheritance tax liabilities on the disposal or on the receipt of the purchase monies by the buyer. All employees get an indirect stake in the company, and the company can also pay out a tax-free cash bonus to their employees of up to £3,600 per annum per employee. And we've actually seen more clients moving towards that employee ownership trust model, the John Lewis model, not just for the tax reasons, and it should never be driven by the tax reasons, but it's a way of dealing with some potential succession planning issues. And yes, succession planning is important, but it's not always enough on its own. And sometimes a straight business sale, what we see sort of the normal M&A that you might think about, achieves actually the best outcome for the current owners. So I just wanted today just to pick up on and give you a brief overview is if you did go about looking to sell your practice, what actually happens from a legal side? And what is the sort of the overview of that? So I'll have a brief look at the legal structure of a sale, the due diligence process that people have to get involved in, what is the key legal documentation, and actually how to go about, if you are selling your practice, protecting the consideration, the money you actually get for it. So there's really two main ways of selling a business. The first is by way of a share sale, and that involves you selling shares of the company that owns the business. And the second is a business or asset sale. And in that approach, the company sells each of the individual assets that it's got that make up the target business. So that might be individual contracts, the cash that it has, etc. And at the end of the process, you would still own the company, but the company then has those sale proceeds. And there's a fundamental difference between the two types of structures. When you sell shares in a company, all of its assets, liabilities and obligations are transferred, even those that a potential buyer doesn't know about. But if assets are sold, only identified assets and liabilities that the buyer agrees to purchase go across. And so there are a few reasons and a few factors that influence why you might structure it one way or another. And the first really is liabilities. Sellers often want to and prefer to transfer the company or group of companies sort of lock, stock and barrel by way of a share purchase. This is because the seller's ongoing liability will be limited to the extent of any kind of warranties or indemnities that they've negotiated with any buyer. But what you often see from the buyer's perspective is that they want to proceed by way of an asset purchase, particularly if they're concerned about historic liabilities, claims records, for example, of a business, or contracts that you've entered into, appointments that you've entered into, which, looking back, now have some liabilities. What they want to do there is they want to cherry pick the assets they want to transfer and effectively leave you with the liabilities. Tax can often play a big role in influencing structure. There's different advantages and different disadvantages of both schemes. And if you're looking at maybe just a partial sale of a business, so there is a book of work that you have that you want to transfer to someone else, it's more likely then that you'd go down the asset purchase or asset sale route rather than the share sale. And also, where there are third-party consents required to transfer assets, for example, if you have a provision in your appointment which says you need the client's consent, which is quite normal to do a transfer of an appointment, in that kind of scenario, you wouldn't be going down the asset purchase route. The only way to actually transfer that appointment might be by way of the whole vehicle, the whole company transferring. So one of the things that any buyer should be doing, and if you are looking to acquire any companies, this is what you should be doing as well, is doing due diligence. And that is the information gathering process carried out by a buyer to find out as much as possible about the target business. This usually starts at the outset of negotiations, and through the process, the aim really is to gain a complete picture of the target and its critical success factors, strengths and weaknesses. The information obtained through due diligence helps the buyer decide whether they want to proceed with acquiring the business, if so, at what price and on what terms. It's therefore vital that sellers don't put a deal at risk by failing to properly manage this important process. Because of the greater risk assumed by a buyer of shares in a company, the level of due diligence required on a share purchase is usually more than an asset purchase, and the focus of the legal DD will depend on the nature of the target that's being acquired. So if it's a structural engineer, I'd expect a buyer to be looking at appointments, the employees, what is your succession plan, claims history, anything to do with your professional indemnity insurance. And the DD exercise generally comprises an assessment of financial, legal and commercial status of the target, and it's carried out by the buyer's financial and legal advisors in conjunction with its own employees. And what they do normally is they send you this very long questionnaire which seeks to kind of go into everything about your business: accounts, assets, insurance, employees, for example. And when you're replying to these kind of questions that come in, it's important to properly manage the process. If you don't do it properly, it causes a lot of problems, and as we'll mention later, it causes problems in what's called the disclosure process. However, responding to these type of questions, a bit like sometimes responding to the questions you may get from a broker or an insurer, can be extremely time-consuming, and you need to prepare for that. So a number of key documents which we need to be prepared as part of the transaction. The first really is what are called the heads of agreement, and you've probably dealt with these when you are involved in any kind of appointment. Heads of agreement are entered into between sellers and prospective buyer. Their purpose is to outline the main terms of the proposed deal between the parties and to provide a structured basis for negotiating formal documentation relating to the transaction. So heads are usually entered into the beginning and before the parties have gone into any kind of detailed due diligence and negotiations of any kind of definitive purchase agreement. So before the parties have incurred any substantial costs. We then look at the next document would be in the case of an asset purchase, the asset purchase agreement, and in relation to a share sale, the share purchase agreement. As well as containing lengthy warranties and indemnities, this agreement deals with how the consideration is to be satisfied, what conditions precedents the purchase may be subject to, restrictive covenants that might apply to you after you've sold, completion arrangements, those sort of things. On a sale, on a share purchase, there'll also be what's called a tax deed, where the sellers agree to indemnify the buyer against various tax liabilities prior to the sale. After the SPA or the asset purchase agreement, the next most important document that you will get involved in is called the disclosure letter. Because under the SPA or the asset purchase agreement, you'd have to be giving lots of warranties and potentially some indemnities about your business. And a warranty is, as I'm sure you know, it's a statement of fact about the business. For example, that the company is not involved in any litigation. If that fact turns out to be untrue, then the buyer potentially has a claim for a breach of warranty and to recover some of the consideration that they're paying for your company. But using the disclosure letter, if, for example, you have had some claims, you are involved in some litigation, you make a disclosure in that disclosure letter, and then the buyer shouldn't be able to bring a claim for breach of warranty. Sellers often wonder why they have to go through this kind of due diligence process to repeat, and then only they have to kind of repeat it when it comes to the disclosures. So it's important to really understand the difference between the two processes. DD, so due diligence, is there to provide the buyer with information about the business and its structure, and disclosure is there to enable the sellers to correct the warranties and reduce their own risk. If the sellers have properly managed the DD process and collated their answers, it should make disclosure much easier. That due diligence letter is divided into two parts, as general disclosures, which pretty much just says to the buyer, go away, look at everything that's on Companies House about this company, look at everything that's on any public records, and then specific disclosures are those very specific disclosures against a warranty in the SPA, for example, the litigation one I mentioned. So once you've gone into this process as well, there's various ways to protect your position. A bit like if you were closing down your practice and you were thinking about getting run-off cover, if you're selling your practice as well, you want to ensure that the documentation that you have has what are called seller protection provisions. And it's rare that a buyer is going to pay 100% for your business on completion. Usually at least a part of that consideration to be deferred, whether that's through an earn-out or on a stage payment basis. The sellers therefore need to conduct their own due diligence into the buyer to ensure they're satisfied that, if there are deferred payments, the buyer is able to make those payments. And that can be achieved in a number of ways, a bit like you might have when you're entering into an appointment with a client. You might ask for a parent company guarantee, you might require the monies to be paid into some kind of escrow account, or you might look for some kind of security. Which of these is appropriate will depend on the nature of the deal and the nature of the parties. And the sellers will usually also try to limit their liability for warranty claims. And you can do this by limiting the amount that the buyer can bring a claim for. So why should the buyer be able to bring a claim against you for the business, which is for more than the consideration or the monies you actually receive? You usually try and apply some time limits around those limitations, so they can only bring a claim for 2 years after completion. And also, they shouldn't be able to bring a claim for anything that has been disclosed to them. So, as we've already discussed, the seller's disclosures against the warranties are one of the main ways they can seek to limit their liability, but full and frank disclosures make it more difficult for a buyer to bring a claim. So, one of the keys to the long-term future of any business is succession planning, whether your practice is to remain independent or you're looking at a sale. My view is that you should start thinking about this process as early as possible. Think about succession planning in your business from day one, from setting up the business, ensure you've got the right documentation in place, and if you then move on to some kind of transaction or some kind of sale of your business, make sure you're looking at how you limit your liability, how you reduce risk, and ensure you get paid. As was mentioned before, my details are on there. We've got a session a bit afterwards where anyone can ask any questions. But apart from that, always feel free to drop me an email. Thank you.